Hello, I'm Anna Woodhook, a Senior Associate in the Family Team at Thompson Snell and Passmore. This month we're looking at alternatives to court when it comes to resolving matters following a separation, whether in relation to finances or children. Today I'm joined by Helen Waite and Kirsty Law, both partners in the Family Team at Thompson Snell and Passmore, and both trained collaborative lawyers. We're going to be talking about collaborative law today, and I wondered, Helen, if I can start by asking you to explain what collaborative law is and why it's different.
So it's a slightly American concept because it started in America, both parties decide that they want to speak to each other as much as possible with the assistance of lawyers. But the purpose of the lawyers isn't to take over the process. In fact, we take a step back and let the parties discuss matters. We're just there to try and point out what might work, what might not work. And the big difference is the lawyers are working together. And everything is done in a four-way meeting or by way of four-way communications. So everything's out in the open.
And is it available to everyone, this process?
It is. In some situations it might not be appropriate, where there's been coercive and controlling behaviour, or where there's such a level of distrust between the parties that it's just not going to be possible to reach an agreement. But in most cases, we would try it to see whether it works in the first instance.
Okay. Kirsty, are more cases suited towards or not towards collaborative law, for example, finances or children matters?
Both finances and children matters can be resolved through the process. The key thing is the parties actually commit to not go to court. So it's only going to work for people that are not looking to use the court process or the threat of court proceedings in the background. But generally, if there's a degree of trust and goodwill, you should be able to work through and resolve both financial and children issues round the table, with the benefit of the lawyers being able to step in and say where people are going off at a tangent that in their experience might not work. So if arrangements are being proposed, the lawyers can reality check it and say, for example, with a bird's nest order, which is very popular in New Zealand, hasn't really taken off so much in this country, which means the children stay put and the parents go in and out. You can find that actually talking through the reality, what happens if one of you meets someone in future, enables people to stop and think, will this really work? But the lawyer's role, as Helen says, is really to assist the parties with their discussions, not to take control of the process.
And we've touched upon this already, but Helen, is there anything in particular that's needed to make the collaborative process a more successful one?
I think the main thing is that both parties have to be committed to dealing with it collaboratively. And what we do at the beginning of the collaborative process is we ask the parties to write down a statement, which is called an anchor statement, which sets out what it is they're hoping to achieve. And quite often they're very similar, so they don't know what the other one said. And we can refer back to that as the process carries on, just to so they can be reminded about why they've dealt with this process, why they've dealt with things in the collaborative process. I think most of the time what they want to achieve is to be able to still communicate at the end of it, to still be able to go to things like graduations, weddings, grandchildren's christenings, and still be able to stand in the same room with each other and not feel that animosity. And I think when you've communicated directly with somebody face to face, it just makes such a difference, as opposed to solicitors' letters going backwards and forwards.
Mm-hmm. Leaves that platform for working together going forward a bit better. And why then, Kirsty, might somebody choose, say, the collaborative process instead of, for example, mediation or one of the other alternatives?
I think it could be particularly useful if, say, the finances are complicated, but there is trust, because with mediation, both parties have their own solicitors, and outside of the mediation process, they will speak to solicitors and take advice, and then the other person isn't hearing the same advice. Whereas with collaborative law, if, for example, you've got a business that you need valued, you can agree the basis on which the business will be valued with the lawyer's input at the time. So both processes are considered much better alternatives to court, because both of them should result in significant cost savings as compared to the legal fees of instructing barristers and solicitors and the delay that the court process takes. But I think if people feel that they want the advice immediately, rather than with mediation where you might explore options and then go and take advice, and also if they want to hear what the other person's advice is, because with collaborative law the advice is given openly, it can be a more attractive process.
Okay, and a parting question for both of you then, perhaps if you can share a top tip maybe when it comes to resolving matters through the collaborative process, what you think is particularly important, let's say.
I think it's having a level of trust. There has to be a level of trust between the parties, because you're signing a document which says you will not go to court, so you haven't got, there's nowhere else to go really. When we're dealing with financial disclosure, you have to be able to produce all the financial disclosure and to trust what the other person's producing. But the main thing is to keep communicating, to be able to speak to each other directly in the collaborative process.
And anything you'd add, Kirsty?
I think I would say that you always need to be remembering that you're doing this for the children's benefit, to enable you to co-parent going forwards. And as I say to both mediation and collaborative law clients, at the end of the day, if you're arguing about the finances but both planning to leave your estate to the children, all you are actually arguing about is who has custodianship of that estate until you die. And don't waste it on the lawyers, don't keep the lawyers in business and spend tens of thousands of pounds. Work out a settlement that you can both live with and preserve the estate for your family's future.
That's really helpful, thank you, both of you. And as I mentioned, collaborative law is just one of the alternatives to court when it comes to resolving these types of matters. And if you'd like any further information in relation to collaborative law or any of the other options, please feel free to contact Helen, Kirsty, myself, or any member of the family department, and we'll be more than happy to assist you. Thank you for listening.